Chapter 5, Drafting of Commercial Contract. The commercial contract meets two objectives. First is that it must simultaneously advance and protect the business interest of the parties. The second and often overlooked goal of a properly drafted commercial contract is that it should not unduly disturb or endanger the commercial arrangement that the two contracting parties have struck. Important clauses of commercial contract. Clauses of commercial contract. First, confidentiality to prevent unauthorized disclosure of the confidentiality information, and dispute resolution clause stating how disputes arising from the transaction will be handled. First, confidentiality and disputes. Details on the court that will have the jurisdiction over the matters arising from the transaction and governing law, especially for the domestic and international cross-border transactions. If cross-border transaction is which jurisdiction we have to go to solve the said problem. So first confidentiality, next dispute, and details of the jurisdiction. If any dispute arises, which jurisdiction. Termination clause detailing how any party can opt out of the arrangements and conditions that will end the contract. Means if these conditions have been met, the contract will be end, like that. And indemnity clause to protect the parties from liabilities caused by a breach of contract or negligent act of the third party. Indemnity. Confidentiality, dispute, details of the jurisdiction, termination, indemnity. Liquidated damages clause to specify damages upon breach of the contract. Force majeure clause to remove liability from failure to perform contractual obligation caused by the unforeseen and unavoidable. Means if unforeseen and unavoidable, no one can do anything, right? Limited liability partnership agreement, LLP agreement. In that contents is first name of the LLP, date of the agreement, and parties to the agreement, name and parties and date of agreement. Introductory provisions, that is definitions, place of the business activity, duration, accounting and auditing, partners contributions and method of contribution like cash or shares or kind, record keeping and bank arrangement, allocation and distributions of the profit sharing, disassociation of the partner, means when a partner can withdraw from the firm, partner's right to records, when the partner can check the records, management and fiduciary duty, and arbitration and general provisions and other provisions. Specimen model LLP agreement or LLP agreement. So this agreement of LLP is made at dash and on the dash between first registered company, LLP name, company registered under Companies Act having its registered office dash through its authorized representative, which shall express unless shall is repugnant to the subject or context thereof, include their legal heirs, successors, nominees, permitted assignees, and son of, daughter of, resident of, which expression shall unless is the subject or context thereof include their legal heirs and all, and is called a second party. So this agreement is between LLP as a LLP partnership and between the partners. So first partner, second partner, and all. And third point also same, the only change is third party. And all the parties here too is the first party, second party, and third party shall be collectively called as, referred to as partners. Where the first party is, second party is, third party is. Now the first party, second party, third party are interested in forming the LLP and under the LLP Act and intended to write down the terms and conditions of the said LLP as below. So name of the LLP, registered office, capital contributions if any, first party how much they'll get, second party how much he'll get, and third how much he'll get, and profit sharing ratio normally equal will be, or else if according to the capital brought in, and the business and objectives of the LLP. Common seal, the LLP shall have a common seal to affix on the documents, and that immovable property purchased by LLP shall be clear, marketable, and admission of a new partner. No partner can be admitted until all the partners agree, and capital contribution required by the new partner and profit sharing of a new partner will be in proportion to his capital contribution. And first schedule of the LLP not to apply. Provision of first schedule to LLP will not apply to LLP, as LLP is governed by the terms of the LLP. So we'll follow our own LLP agreement. We don't need any first schedule or second schedule and all. And remuneration and interest to the partners. Remuneration will be paid as majority of the partners decided, and LLP shall pay the interest as decided by the majority. And if any partner advances any sum money over and above his contribution, the same shall be debt. So over and above capital contribution, if we give any, that is in the form of debt considered, and shall carry a simple interest at a rate of %. Okay. Rights of the partners, what and all they have the rights. Rights of the partners, all the partners here means all the partners have the rights in all the assets and properties, and all the partners have the shall be working partners only, and every partner have access and can inspect and can have the copy of any books, and each partner shall be entitled to carry on their own separate business, provided they should not use the name of the LLP to carry their own business. And LLP have the perpetual succession. Death or retirement of any other partner will not dissolve the LLP, and on retirement on the retiring partner will be entitled to full payment rights in title and interest. And if in case of insolvency, that will not be there. Title interest will come to it, and on the death, their legal heirs can be admitted as a new partner, and whatever is paying to the deceased partner will be paid to the legal heirs, and full payment and rights will be there. On the death, if any legal heirs not opt to become the partners, and surviving partners shall have the option to purchase the contribution of the deceased partner. Duties: every partner shall account to LLP for any benefit derived by him without the consent of LLP, and each partner shall be just and faithful to the other partners, and every partner shall indemnify if any loss caused by it his or her frauds because of their act loss caused, so they should indemnify, and each partner shall render true accounts and full info. And in case any partner desires to transfer, first they should give the chance to the remaining partners. If they by 15 days notice, in 15 days if they are not accepting, then go for outside market. And no partner shall without the written consent of LLP shall engage or dismiss the employee, and employ any money, goods, effect of the LLP or pledge thereof in pledge as a credit except the ordinary, and lend money or give credit on behalf of LLP, and have any dealings with the person who previously in writing forbidden to deal with, and any loss incurred or any breach of the provision shall be made good to the LLP by the partner incurring the same, and enter into any bond, bail, become guarantor, surety, security for any person knowingly and do cause or suffer to be caused anything whereby the LLP property may be seized or endangered, and assign mortgage, charge in the LLP or any asset property, make any other person as a partner. This all cannot be done, and compromise or compound or re-release or discharge any debt due to the LLP cannot be done, or unless if it is paid in full, then they can discharge, and engage directly or indirectly in any business that is competing the LLP business. Meetings of partners of LLP. All matters relating to LLP as schedule according to Schedule B shall be decided by the resolution passed by the majority, and each partner will have one vote. The notice for the meeting will be sent 15 days prior to all the partners at the residential address or email. If a partner is a foreigner, for him through the email, and in case of any urgent meeting, if majority of the partners agree, after the meeting and before the meeting, either way can be get ratified by all the partners. So notice requirement is not so important here. Either after meeting and before meeting, in both can be ratified. Meetings at registered office or any other as decided, and if written consent given by all the parties, meeting can be conducted through teleconferencing or video conferencing. Written consent of all the partners required if a meeting want to conduct through teleconferencing or video conferencing, and LLP ensure that decision taken will be recorded within 30 days from the decision taken, and duties of the DP and AR of the first and second party shall act as a DP according to the LLP Act requirement. So DP shall be responsible for the acts and all he done in according to the LLP in respect of the compliance of provision of LLP, including any filing of docs, written statements and all. And DP shall be responsible for doing all the acts arising out of LLP agreement. And each partner punctually pay and discharge the separate loans, debts, indemnify the other partner and LLP assets against any loss caused or suffered, and all the proceeding costs, claims and demands from the LLP in respect thereof. Books of accounts of LLP are kept at the registered office for any references, and accounting year shall be from 1st April to 31st. And the first accounting year is from date of commencement of LLP till 31st March of subsequent year. Bank account. Banker of the partnership shall be so and so, and if they want to change, they can change. if majority or unanimously accept. And bank account and financial institution taken by the LLP may be opened and operated by the DP if by the partners or singly DP and partners or alone partners as may be agreed upon. And extent of liability of LLP. LLP is not bound by anything done by a partner in the dealing with a person if the partner in a fact has no authority to act as a LLP in a doing so particular act, and the person knows that he has no authority nor he does not know or believe him to be a partner of the LLP. Indemnity. LLP shall indemnify each partner in respect of payments made and personal liabilities incurred by him in the ordinary and proper code of conduct of business, and is done anything to preserve the business or property. LLP will indemnify all and defend all the partners. That is, LLP will act as a guardian, security guard for partners, officers, and all. If except if they acted gross negligence and willful misconduct, then it will not provide any indemnification. And disputes, if any cannot be solved through LLP agreement, will be referred to arbitration. Any partner who wish to cease should give the notice of 30 days before he want to intention of resign of partner. And majority of the partners also cannot expel any partner except situation where any partner has found guilty of carrying business activity or LLP in a fraudulent purpose, winding up of the LLP only with the consent of all the partners, and in witness whereof signed by party 1, 2, 3 and the witness. Next, these are the matters. If LLP agreement is not there, how they will decide. This is the illustrative. If there is no clause related to any item in LLP agreement, this can be the guideline to follow. So first, mutual rights and duties will be determined according to the LLP agreement, if no such agreement, according to the provision of this schedule. And all the partners shall share equally profits and losses. And LLP shall indemnify each partner of the payment and made personal liabilities incurred if in the ordinary course, and to preserve or business or property done any act. And every partner shall indemnify if he did any caused any loss by doing the fraud in the business conduction. Every partner should take part in the management, and no partner shall be entitled to the remuneration for acting as in the business or management, only profit sharing ratio. And no partner can be introduced without the consent of all existing. And any matter shall be decided by the resolution by the majority. Each one will have one vote. And if there is no change in the business and all, without consent of all the partners also can proceed. And the decision taken by it will be recorded within 30 days in the minutes, and kept at the registered office of the LLP. And each partner shall render true accounts and full info of the LLP to any partner or legal representative. If a partner carries on business that is competing to the LLP, and he must pay over the LLP all profits made by him in that business. 12th point. Every partner shall be accountable to the LLP for any benefit derived by him without the consent of the LLP, because they have used the partnership or its property, or in the name of the partnership they have did. And by the majority of the partners cannot expel any partner. And all disputes, if cannot be solved through LLP agreement, will be solved through arbitration and conciliation. Done with LLP. Joint venture. Joint venture JV means a strategic arrangement between two or more businesses where resources are pooled to work together on a specific project or on an ongoing basis. JV are a useful way of collaborating with other business and to combine different areas of the expertise for a targeted or general business purposes. Each of the participants in a JV is responsible for profit, loss and cost. However, the venture is own entity separate from the participants and other business interests. It is important that the parties to joint JV define their respective roles and responsibilities early on, and how the parties will work together to achieve the venture's business. And parties should assess the deal is for a short or long term arrangement, whether a separate company should be set up for the purpose, whether it is a purely loose collaboration agreement, or whether there is a view to merger or acquisition in the future. Contractual JVs can take form of two or more parties coming together to collaborate on a specific project, share the cost of R&D and act or share knowledge and expertise on ongoing business. Partnership where two or more parties start working together and carry on the business in common viewpoint of the profit, they will form a de facto partnership. And important clauses of JV agreement. Parties to the JV: business object, purpose of JV, structure of JV, final arrangements, management, distribution of the shares, contribution of the parties, rights and obligations, representations and warranties, indemnity clause, non-compete clause, exit mechanism and termination, force majeure, dispute resolution, confidentiality. So JV of with foreign company, first one is US company and second is the Indian company, and US company is the manufacturer and dealer of computers, hardware, software and all, and Indian company is the manufacturer of dealer in exporter of computer software, and intends to expand its business in India and abroad. So US is thinking to a market in India, and India company is thinking India and abroad. So they both come together and by setting up of a new company. So joint stock company would be formed under the name of Style of Indo-American Company and under the Companies Act and having the registered office at Dash. So each company have the 3 members, 3 nominees, and they will be the subscribers to the MOA and AOA, and share capital in equal proportion. MOA and AOA with the mutual consultation will be settled, and the same would govern the rights and obligations also. Means in that rights and obligations also should be governed of both companies. And US company will give cash and plant and machinery and equipments, and also it will assign all the IPR related stuff to the new company. So in consideration it will be allotted shares in the new company. And Indian company will supply the technical and expertise assistance as it required for smooth running of the new company, and it provides selling processes as required by the new company from time to time. And Indian company will advise and furnish the technical assistance and advice in relation to the operation of a plant and machinery, reports and testing facility thereof, and also R&D will be arranged by Indian company. Normally the shares allotted to Indian and US, they cannot transfer the shares within the period of 5 years, and thereafter if they want to means US company want to transfer the shares, then first offer should be given to Indian company at a price determined by the valuer. New company will manufacture the computers, hardware and softwares, and same would be marketed in India and exported to other countries under the trade name and brand name made available by US company. And US company will buy the 75% of the product from the new company for exporting purpose at a remunerative price and not below the price at which products are sold in the India. And neither the parties shall carry on their own business which adversely affect the business and profitability of new company. Expenses shared equally. Consideration for allotment of shares of the new company shall be paid in cash and kind, and valuation of such immovable property will be decided by mutual agreement between two companies. And any disputes arise, they will go to the arbitration and conciliation, and arbiter shall be final and binding on both the parties. This agreement shall be subject to obtaining approvals from the Indian government. And if government gives any additions or alterations, it will be incorporated and as a supplemental agreement. And if required, MOA and AO of the new company would also be conformity directions of appropriate authority. In witness whereof sign Mr. First US company and next Indian company, and signature and witness. When two parties join hands for the exchange of technical know-how, technical designs and drawings, and training of technical personnel of one party in the manufacturing and R&D division of other party, continuous provision of technical, administrative, managerial services, they are said to be collaborating in a desired venture. Collaboration means cooperation between a party within India and a party abroad. This agreement drawn and executed between such collaborating parties known as FCA. Guidelines for entering into FCA, where FCA with equity participation is involved, and the value of shares to be acquired about be brought in cash. Indian company will pay to the foreign company, that is foreign collaborator, in 3 installments. First 1/3 are paid after the agreement has been approved by the CG, and 1/3 transfer of technical documents, and 1/3 on the commencement of commercial production. Indian company will pay foreign company a royalty, and it is calculated on the basis of net ex factory selling price of the product less excise duties and cost of imported components. Normal rate of royalty may be from 3% to 5%. Duration of agreement is minimum 5 and maximum 8 years. And if CG thinks fit it should be extended, if CG will extend the renewal. Sublicensing is however subject to the CG approval, and agreement shall not normally impose any restriction for sublicensing. No foreign collaboration shall be allowed to contain any restriction on free export to all the countries except in case where the foreign collaborating has the licensing arrangements in case the countries concerned in the specified. There should be no restriction on procurement of capital goods. The Indian collaborator must be free to have the control over the pricing facility and selling arrangements. Technicians, the number, term of service, remuneration, etc. of technicians to be deputed by, if deputed by any of the companies, subject to the approval of RBI. Training provision shall be made in the agreement for adequate training facilities and R&D. Exploitation of Indian patent. Where any item of manufacture is patented in India, the payment of any royalty or lump sum for the use of such patent shall be paid compensation for the foreign company by the Indian company. If necessary for any consultancy services, it should be obtained from the Indian company. Even if in special circumstances also, then also Indian only should be consultant. Brand name, no insistence or objection to use the brand name of a foreign brand name on products, and applicable law, all Indian law should be complied with. Approval of CG. Without this, foreign collab will not happen. And two important clauses is: first, agreement shall be subject to Indian laws, and agreement shall be subject to approval of Government of India. And specimen foreign collaboration agreement. First is foreign company, because foreign is providing and India is receiving. So first foreign, second India. Indian company incorporated with the object of manufacture and production of so and so, and construct the factory building and install the plant and machinery and commence the business as well. And to improve the quality of commodities manufactured and to increase the production, is desirous of procuring the latest technique and know-how, and therefore the Indian company approached the UK, and UK has considerable experience in the same line of business, and requested the UK to extend the Indian company necessary technical assistance. In this behalf, UK agreed and extend the technical assistance and furnished to Indian company for improvement of their business and requisite know-how. Also to provide Indian personnel necessary technical training to enable them to successfully handle and exploit the technical know-how. Indian company should make the remuneration to the UK company, and UK company should supply the Indian company as follow. First, technical advice and know-how, and necessary plans and factory design, layout, charts and drawings, and render the advice in the matter of purchase of the further plant and machinery, and lend the services of their technicians to assist in Indian company for installing the additional plant and machinery, and to provide technicians from their own staff to attend the Indian company, to impart the technical training to selected Indian personnel, and to exploit the imported technical know-how to the best advantage, and if advise the Indian company promptly to the best of their ability in connection with any technical or manufacturing problems and difficulties, and referred by the Indian company during the continuance of this agreement. And lump sum payment, one third. First 1/3 CG approval, second 1/3 technical data and all, and third 1/3 after the commencement of the production. And 5 years, for the 5 years this foreign collab will happen, and can use the brand name, and no restriction on the Indian company to export, and Indian company shall not have any right and all, means they cannot do any transaction which can affect the interest of the foreign company without the written consent, and there shall be no restraint on the Indian company for procurement of raw materials or purchase for their production of products. And the technicians who have deputed by the UK to the Indian company, the salary will be paid by the Indian company itself, more than enough. And close the deed. Joint Development Rights Agreement, also known as Strategic Alliance Agreement. In a JDA, a landowner contributes his land for the construction of a real estate project, and the developer undertakes the responsibility for the development of the property, obtaining approvals, launching, marketing the project. This agreement should be registered in the court of law. The agreement bounds the landowner and the developer in the agreement for the construction of new project in return for the land provided by the former. Percentage of sales revenue, or a certain the latter agrees to provide some provisions. The developer agrees to provide lump sum consideration, percentage of sales revenues, or a certain percentage of the newly constituted project. In this manner, this depends on the terms and conditions mutually agreed upon by the parties. In this manner, the resources and efforts of landowner and developer are pooled together so as to bring the maximum productive result. So the cost of the land is a real estate is a substantial part of the total cost, and the developer is not required to make investment for acquiring the land at initial stage. On the other hand, the landowner, who may not have the requisite experience and expertise for developing, gets better price for his land in comparison to what he would have got in case of outright sale of land. Thus, it creates a win-win situation for both of the parties. The following points should be carefully observed, which may have legal and tax implications of the wide ramification. When the ownership will be transferred and possession of the land is handed over, or not, like only the to just enter upon and possess land only for the development, or developer enjoys the possession of the land beyond that, that is whether there is a transfer of ownership or beneficial rights in the land or not. And fifth point, whether rights and authority to the mortgage the land granted to avail the credit facilities, and in what manner and at what point the legal title or ownership of the developed unit is acquired by the customers. Whether the terms provided in joint development agreement may result into creation of a separation legal entity or JV in the form of association of a persons or otherwise. Whether the terms of joint development agreement result into the conversion of the land from capital asset to the business asset, which may alter the chargeability of the tax liability altogether. Done on the basis of this, we can go with the specimen format. Service agreement already done in other chapters. So necessary provisions for service agreement: time or period of employment, the remuneration and other perquisites, if any, including pay, allowance and commission, duties and power of the employee, leave and terms on which it will be granted, modes and ground for determining the employment during the term, and restrictive covenants, if any. For other employment contract, the important terms are discussed. First, period of service, remuneration, leave, determination of the employment, restrictive covenants, effect of labor law. And specimen: whereas the employee want to appoint a suitable person to work as a manager for his business concern, and CD, the party of the other part has agreed to serve as a manager for the employer of his business concern. So think of manager, what and how he'll do, that all we should write. So first, manager shall work as a for such term, so period of his work, and the manager shall give his whole time and attention to the said business and shall use the best endeavor to improve, and all respects diligently and faithfully obey and observe all laws and orders, and the manager shall keep at place of business proper books of account. And fifth, the employer shall, during the continuous manager's engagement, provide him with a suitable furnished house for residence, free of rent, rates and taxes. The manager shall make use of tour as may be necessary, if in the interest of the said business. The manager shall be entitled during his engagement to leave on a full pay for a period of equal to 1/11th of the period of service rendered. Either of the party can terminate this engagement before the expiration of the said term. If manager at any time willfully neglects or refuses, or from illness or other causes become unable to perform any of the duties under this agreement, the employer may suspend his salary during such neglect or negligence or inability as aforementioned. The manager will at his own expense find and provide two respectable sureties to the amount of rupees each for his good conduct and for the due performance. In witness for a formal part and done. Specimen renewal agreement of term of service of an employee. So in this renewal, all things remain will same, and post and salary may change. The agreement has been expired on so and so date, and it has been agreed that the said employee will be re-engaged the said manager upon the terms and condition appearing here, and the said manager shall serve the said employer as a manager for 1 year from the date. In witness whereof and formal part over. Dealership agreement, distributor agreement and franchisee agreement. A dealership agreement is a legal document that outlines the terms of the contract between the distributor or vendor and the dealer. A dealer agreement can also be govern the business relationship between general dealer and a vendor. These agreements can get more complex and lengthier depending on the size of the manufacturer and dealers involved in the agreement. A dealership agreement with a larger manufacturer can include obligations of a dealer, such as requirements of the facilities, rules around dealers' employees and the personnel selling the requirements, common selections included in the dealership dealership agreements are purpose of the agreement, tenure of the agreement, obligations of the parties which may include, and procedures of a supply and return of the goods, promotion and training, invoices and the mode of the payment, any restriction upon the parties' termination of the dealership. Distributorship means the legally binding contract between the supplier and the distributor, in which the distributor purchases and sells items from the supplier in order to sell them to the retailers. And distributorship, there are two types, exclusive and non-exclusive. In exclusive means like in area there are many distributors. Is a exclusive, and non-exclusive is for the particular area there is only one distributor are there. So agreement between manufacturer and the distributor is a distributorship, and agreement between distributorship and a dealer is a dealership. The following is the checklist of the factor to be considered when drafting a distributorship. First, exclusive distributor or distributors, terms and condition of the sale, term for which the contract is effect, duration, marketing rights, trademark licensing, geographical territory covered by the agreement, performance reporting, returned goods, defect, circumstances under which the contract may be terminated. Differences: distributor involves manufacturer and distributor, while dealer involves distributor and a vendor and a dealer, or vendor or a dealer. Dealers such as retailers or value-added resellers buy products from distributors and resell them to the consumers. Distributor operates as an intermediary between the supplier and the dealers. In a distributor dealership, the scope of both agreements also varies. Distributors are often assigned territorial rights, while dealers typically limit the operations to a city or local community. And investment in distributorship more and dealership considerably low. Distributors are the wholesaler who buy from the manufacturer and provide to the dealers, whereas the dealers obtain products from the distributors to sell to the public. Dealership agreement often outlines the conditions of a sale of items acquired from the distributor. Franchise agreement is a legally enforceable contract between the franchisor and franchisee. This agreement authorizes a franchisee to open a franchise site while also granting the ability to use franchise-specific resources such as branding, business methods, and supply sources. A franchise agreement, like any other agreement, any other contract, is intended to define precise conditions for the parties' relationship. These agreements provide safeguards and duties that benefit both parties. Franchise agreement define limitation within which the franchisee and can operate and clarify any financial commitment they have to their franchisors. So what should a standard franchise agreement include? Basis of agreement: grant of franchise, agreement's duration, fee of franchising, operations management services provided by the franchisor, safety of intellectual property, training, advertising, limitations, obligations, royalties, quality assurance, indemnification, geographic restrictions, insurance restrictions, and non-compete covenants. And franchise and distributorship difference between is there. And specimen of a dealership contract: so company appoints a firm as a dealer to sell the products. So it is first one is appointment, and for how much period the dealer will be appointed by the company is second one is term. And the minimum stock, how much should be each of the company products to meet the demand, how much minimum stock should be kept. And credit period, how much credit period as a okay between company and the dealer. And advertisement related, and the company and the firm shall settle their accounts every 6 months, and to promote a sale of a company's products, and terminate when they can terminate within 15 days of the receipt of each purchase order. So the company agrees and undertakes to supply to the firms its products as per the firm's order, and in the event of company failing to supply the ordered goods within the 15 days of receipt of each purchase, the firm shall entitled to terminate the agreement by giving the company 1 month notice. And at the end of the notice, this agreement shall stand terminated, and the parties shall settle their accounts within 7 days of such termination. The firm shall not sell any product of the company at a higher price than the one indicated by the company. The firm shall have the liberty to appoint sub-dealers, salesmen, commission agents. Specimen of distributorship. So first, distributor. So whereas A is a wholly owned subsidiary of A Investments Limited and engaged in the business of A appoints distributors for sale of the products through wholesale outlets. The party of the other party is a merchant or trader with familiarization experience in the business with sound financial background. The other party had approached A for the appointment of a distributor to purchase and distribute the products on a wholesale basis. So distributor appointed, and next basis of the agreement, seller and buyer, not the principal and agent. Right to appoint other distributor, shall have the right to appoint the other distributor in respect of any or all the products, and to sell any or all the products at any time, and order or placement acceptance. Distributor shall place the order with A for the supply of products with the remittance as provided. The quantity order for each individual line should be multiple of standard pack size. Terms and conditions and sale price as distributed. The sale price of a buyer A to distributor shall be rates chargeable as per the list of a dispatch. Maximum retail price and payment. Hold the goods in the trust. So distributor holds the goods in the trust. Lien on the goods. A shall have lien over the goods or the value and other materials which are in the possession of distributor till the receipt of payment. Unpaid check, dispatch, delivery, failure to take delivery, claim on the quality, distributor service and suppose, business promotion, optimum level stock, information and records, and many more. So by using these points only we can form easily specimen. If we know the meaning of franchisee, we can. If we don't know the meaning exactly what is franchisee, we cannot do the specimen or points to be kept. Outsourcing agreement is similar to the service agreement only. Any non-strategic activity will be outsourced to the expert. So two types are there: business process outsourcing and knowledge process outsourcing. For business process outsourcing, normally not required to outsource, but knowledge skill required. So example, hire a CS for legal related. Outsourcing is the contracting out of the company's activities to the specialist. It differs from the contracting in that outsourcing is a strategic management tool that involves a restructuring of an organization around what does its core competencies. Two common types of outsourcing in IT is BPO and KPO. Before signing an outsourcing agreement, the following factors must be properly addressed: duties and obligations of the outsourcer and service receiver, securities and confidentiality, legal compliance, fees and payment terms, proprietary rights, auditing rights, applicable laws to the outsourcing agreement, term of the agreement, event of default and addressing, dispute resolution mechanism, time limits, location, number of arbitrators, interim measures, privacy agreement, non-compete agreement, confidentiality agreement, rules applicable, appeal and enforcement. Be aware of the local peculiarities, survival terms, and after the termination of the outsourcing agreement. Here they gave a specimen that is related to business process outsourcing. Non-disclosure agreement. It may come in the drafting or in CMDD. So important. NDA, which sometimes also referred to as confidentiality agreement, is a legally binding contract that establishes a confidentiality relationship. The party or parties signing the agreement agree that confidential or sensitive info that they may obtain will not be made available to any others. And the key elements of the NDA are: first, identify the party, definition of the what is deemed to be confidential, and the scope of the confidentiality obligation by receiving the party. The exclusions from the confidential treatment means they can be disclosed. The term of the agreement. Next, specimen. So both the parties of the business have to enter in, they are thinking to enter into the potential business arrangement, that is proposed transaction. For this, both the parties may exchange certain documents relating to each other business, assets, financial conditions, operations, and many more they are discussing. So these all should be made confidential, so they are entering into the agreement. And whereas each party wishes to review such confidential info of the other for the sole purpose of determining their mutual interest in engaging. So they want to engage into the business arrangement. Only for that purpose they are sharing the material info, and that material info should be used only for such purposes only. And in connection the above, parties hereby agree as follow. And in the first point, what is a confidential or proprietary info is defined: shall mean and include any information disclosed by one party, that is disclosing to the receiving party. Here in this case both parties are disclosing and both parties are receiving, because he will share his info and he will share his info to enter into the arrangement. And second point, receiving party shall refrain from disclosing, reproducing, summarizing, or distributing the confidential info and confidential materials of the disclosing except in connection with the proposed transaction. So only for the proposed transaction only they can do any disclosing and reproducing, summarizing, and any other they can't. And third point, the parties should protect confidential info, like they are protecting their own confidential information. And the property that is disclosed by the disclosing party should always be the party of himself only. The receiving party cannot be copied or reproduce the same party without prior consent of the disclosing party. And next, within 7 days of the written request by the disclosing party, the receiving party either return, so he'll just you gave me the documents, I'll return to you, or destroy as may be requested by the disclosing party, or upon the expiry of the term they fixed, or earlier termination also possible if they breach or anything. And all original copies, reproduction and summaries of the confidential info provided by the receiving party as a confidential info. And receiving party shall certify that disclosing party in writing that it has satisfied its obligation under this paragraph. Means either written or destroyed, both any one has been done. So this is a written statement, or in writing I am giving for you. And the receiving party may disclose the info on need to know basis only. Means only when required, only then should share the information. Need to know basis, if no need arises, should not share, simply. And confidential information, however, shall not include any info if it is if the info is in public domain and was already in its possession, free of any such restriction. Means no restrictions, you can use however you want, like that. And was independently developed by the receiving party without making use of so I myself has made, so I can use however I want, independently developed by the receiving party and has been approved for release or use by a written authorization. So disclosed party only said okay, you can make release or use the confidential info, then also okay. And in the event of party receives a summons or validly issued administrative or judicial process, so court related or judicial related, if asked to produce, they have to produce. And neither of the parties shall use other names, trademarks, proprietary words, anything related to others they cannot use with the written without the prior written approval, And 12th point, neither the party shall be liable for any special, consequential, incidental damages or losses, regardless of whether a party was advised of the possibility of the damage or loss asserted. Means the loss happened or anything happened is out of the hands or out of the power, so no one can do anything, so they will be not liable. And both parties cannot disclose the information, and the parties reserve the right to disclose only information at their own discretion. And the provision of this agreement shall survive and continue after expiration of termination of this agreement for the period of 5 years from the date of expiration. Each party warrants that it has authority to enter into agreement. More than enough. And in witness whereof and formal part over. Electronic contracts, e-contracts, direct question or case-based question, either the question may come. And remember one thing, like at the end of the lesson there will be topics, like now we have e-contracts. At the end of the chapter there will be one or two topics that topics are very important from the examination point of view. So prepare well the topics which have given at the end of the module chapter. Like now for the 5th chapter ending, there is a topic like e-contract is also important, and the previous topic, that is NDA, both topics are important. This applies for all the subjects, like the chapter ending 1 or 2 topics will be important for all the subjects, all the chapters. Focus. E-commerce is the selling and purchasing of goods and services using technology. E-contracts are basically the contract analyzed with e-commerce and other transactions taking place in digital environment. E-contract is any kind of a contract formed in the course of e-commerce by the interaction of 2 or more individuals using electronic means, such as email, interaction of an individual with an electronic agent like electronic agent Flipkart, such as computer program, or interaction of at least two electronic agents that are programmed to recognize. This is known as electronic contract. Like when we go through the Flipkart, first they will ask agree to the terms and conditions. So there is an e-contract between the platform, that is Flipkart, and we customer. And for seller also same thing, seller and Flipkart will be entered into the contract, that is a e-contract signed between seller or purchaser or commerce operator, that is Flipkart. Electronic contracts are born out of the need for the speed, convenience and efficiency. And here they gave an example, like two parties, they want to do the contract. So first both of them meet and they will say these are the terms and conditions, and they both will see one after the other. One will sign and give to the other, and other will sign. This whole process. So in electronic, the whole transaction can be completed in seconds, where both the parties simply affixing their digital signature to an electronic copy of the contract. So contract is been done. There is no need for any delayed couriers and additional traveling cost in such a scenario. Contract formed through the electronic media are treated as general contract only, and their formation and acceptance are governed as per the Indian Contract Act. And according to the Indian Evidence Act also deals the presumption as to e-records, providing the electronic records as a evidence in a disputed manner. So e-records will be accepted if in case any dispute is there. E-records can act as an evidence. Essential of the e-contract: an offer or proposal by one party and acceptance of that other by the another party, resulting in an agreement, consensus ad idem. And intention to create a legal relation. If you know, like Indian contract points here are the same also. And the intention to create a legal relationship, and intent to have a legal consequences. The agreement is supported by lawful consideration and legally capable of contracting, that is a competent party. And genuine consent between the parties. The object and consideration of a contract is legal and not opposed to public policy. The terms of the contract are certain. The agreement is capable of being performed. Therefore, to form a valid contract, there must be agreement based on genuine consent of the parties, supported by consideration made for a lawful object and between the competent parties. Types of e-contract: click wrap or web wrap, shrink wrap, EDI, online shopping agreement. In first one, there are further two types. First, type and click, and second, icon click. Type and click, icon click. Meaning, these are the agreements which are which we generally come across while surfing internet, such as I agree to the terms, or I disagree to the above conditions. A click wrap agreement is mostly found as a part of the installation. So while installing, we'll come to the come across of the installation process of software packages. It is also called as click through agreement, or click wrap license, click wrap. So this is also known as first click through, click wrap, web wrap. Three names are there. Like when we watch any movies in the OTT, this is the thing we'll go through. Next, types: type and click, where the user must type I accept or other specified words in an on screen box, and then click a submit. So first we have to type I accept, and then we can submit by clicking a submit button. The display acceptance of the terms of contract, and the user cannot proceed to download or view the target info without following the steps. So first he must type I accept and then click the submit, only then it will be open. And icon clicking, where the user must click on and okay, I agree dialog box will be popped up. So icon click, dialog box or pop-up. On that we have to click OK or I agree. And the user indicates rejection by clicking cancel or closing the window. If close or cancel, it is a rejection, that I don't want to accept to the terms. And upon rejection, the user can no longer use or purchase the product or service. A click wrap agreement contract is a take it or leave it type of a contract that lacks bargaining power. No bargaining power, bargain direct. If you want, accept, no, leave it. Shrink wrap agreements. Shrink wrap contract or license agreements or other terms. License agreement or other terms and conditions which can only be read and accepted. So read only memory, like that, which can only be read and accepted by the consumer after opening the product, like CD-ROM of a software. The terms and conditions are printed on the cover of CD-ROM. Sometimes additional terms are imposed when in such licenses appear on the screen. When the CD is downloaded to the computer, the user has a right to return if new terms and conditions are not to his liking. So these are the license agreements or other terms and conditions which can only be read and accepted by the consumer after opening the product. Like any banks app also same thing will be followed. There will be a license agreement displayed, and for that we have to accept, and we can't change anything, just we have to read and accept, and only then the app will open. Next, EDI. This contract used in a trade transaction, trade EDI, the trade, EDI for trade, which enables the transfer of data from one computer to another, from data of one computer to another. In same entity, there is a topic in a merger or amalgamation, creation of data room and inspection of a data room. Same like EDI will be used for that. So to close the deal of merger or amalgamation through EDI we can do. So this contract used in a trade transaction which enable the transfer of data from one computer to another in a such a way that each transaction in a trading cycle can be processed with virtually no paperwork here, unlike the other two is exchanging of information and completion of a contract between two computers and not an individual and a computer. Online shopping agreement. Suppose X Limited wants to offer online shopping services to customers. X would tie up with a manufacturer of books, toys, clothes, etc. and offers their product for sale through websites. Some of the product could be stocked in Vice warehouse, while others could be stocked with the manufacturers. Additionally, the visitors can post, review, comment, photos, etc. on X website, and X would need to enter into contract with all the potential customers before they place an order for the product using X services. This contract must serve the following purposes. Think of Flipkart, Amazon, any e-commerce platform. First, what they will do, outline the scope of the services provided. Outline the scope of services provided by the X Limited. So if X Limited, like any food related you take, so and so restaurant having only some of the food items list. So scope of the services, will they provide only afternoon or dinner or even breakfast, like scope of services they are into. And restrict X liability in case there is any defect in the product sold through the X liability. If I found any default in the product which I placed order, what is the restriction or X liabilities, how much he is liable. And outline the duties and obligations of the customer. Obligations of the customer. Grant suitable license to the customer to use X website. Grant suitable license to the customer to the use X website. And restrict Vice product liability in case of a loss or damage suffered by the customer as a direct or indirect result of the X website. If liability arises because of website, what can Y do? Means the seller, what can he do if platform is did any damage? Seller cannot do so. It's platform liability. Important points in regard to e-contract. So here the X is like a seller or manufacturer. So customer relation means buyer relation with the seller. Acceptance of the terms of the contract. The contract must clearly lay down that a customer cannot use the X website unless he agrees with the terms of the contract. The customer can usually indicate his acceptance by clicking on I accept link or checking an I accept checkbox. So even checkbox will be given, only we have to do tick or I accept. Copyright. The contract should clearly state all the consent included in the X website, such as text, graphics, logs, and etc. is a property of X Limited. No customers' duties and obligations. Not the contract should clearly lay down the duties and obligations of the customer. Among others, the customer must not overload Vice system, not download or modify the X website, and collect and use any product listing, descriptions or prices, download or copy account info by data gathering and extraction tool, not frame or utilize framing techniques to enclose any trademark, logo or other proprietary information, not use any meta tags or any other hidden text, and license from Vice. license from the Y, the contract must forbid the customer from following acts in respect of said software. First, copying, he cannot copy the software. Modifying, he cannot modify, and creating a derivative work of derivative. Reverse engineering, he cannot do. Decompiling or otherwise attempting to extract the source code. The contract must mention that the customer cannot assign sublicense or transfer his right to use the X software. Review and comments. The contract should specifically mention that review, comment, photos, etc. posted by customer should not be illegal, obscene, threatening, defamatory, or any other. And it should also mention that such content should not consist of any content, software, viruses, political campaign, commercial solicitation, chain letters, mass mailings, etc. and in the form of spam. Risk of loss. X has a shipping contract with various courier companies to deliver the products of the customers. The contract should clearly state that once the product are handed over to the courier company, X liability end there. Pricing. The contract should clearly clarify how the prices listed on X website are computed, how prices have been computed, the brief of it. The various options could be: listed price represent the full retail price listed on the product itself. The listed price is suggested by the manufacturer or supplier. The listed price is estimated in accordance with the standard industry practice. The listed price is estimated in accordance with the estimated retail value of a comparably featured item offered elsewhere. Prohibition. The contract must specifically prohibit the following. First, using deep link, page scrape, robot spider to access or acquire, copy or monitor any portion of the services. So any copying not allowed. And reproducing the navigational structure or presentation of the service. Circumventing the navigational structure or presentation of the service. Fourth, attempting to gain unauthorized access to any portion or a feature. Harvesting or collecting usernames, probing, scanning, testing the vulnerability of the services, tracing the info related to other users, and using the service for any unlawful purpose, and applicable law according to law should be followed. And limitation liability. The contract must clearly mention that X Limited and its subsidiary affiliate licensor will not be liable to the customer for access delay or interruptions to the X website. Means related to website, what can the manufacturer or seller do? Loss of the registration or processing of an order. So in processing of an order, any issue came, that is with the website itself, not the manufacturer company. Unauthorized use of customer's account with Y, and unauthorizedly my account someone has been used, so that is also related to website issue. Deletion or failure to store or failure to process act upon email messages sent by the customer to the staff. So something they have been deleted or not accessed properly, or failure to store, process, and error taking place with regard to processing of the customer order. So error is happening while I am placing the order. And any direct or indirect, incidental, special, consequential, or exemplary damages incurred by customer pursuant to using of that website. And any loss of profit or goodwill, any loss or goodwill of the business reputation, any loss of data suffered, caused, procurement of substitute goods or services, any other tangible loss incurred by the customer pursuant to X website. So if customer got the loss due to the website related any info, manufacturer or the seller will not be liable. Changes in or cessation of the X services. Customer failure to keep his account info, password secure and confidential. Customer himself has been failed to secure his own info. Next, exclusion of warranties. Exclusion of warranty. The contract must clearly mention that the customer expressly understand and agrees that use of these services, that is any e-commerce platform, is at sole risk, and that services are provided as is and as available. The contract must expressly disclaim all the warranties and conditions of any kind, and do not represent or warrant that the X services will meet the customer requirement and the X services will be uninterrupted. Sometimes there is any interruption in the e-commerce platform like Flipkart and all, there will be interruption. So he cannot give a warranty that all the services will be uninterrupted and timely, secure and free from the error. He cannot give that warranty, and the information provided by or through the X services will be accurate and reliable. That also can't be said. The information may be not accurate and not reliable also, and the defect in the operations or functioning of Y services will be corrected. Ending of relation with X and customer, that is uninstalling. The contract must lay down that customer can terminate the contract by closing all his account with Y. X must retain the right to terminate the contract under the following circumstances. The customer breaches any provision of the contract. The customer acts in a manner that clearly shows the intention to breach the provisions of the contract. X is required by the law to terminate the contract, and the provision of services to the customer is no longer commercially viable. And we are done with chapter 5. Happy